Good morning, everyone, and welcome to Part 2 of the Acquisition 101 course from the ODOT Real Estate Academy. My name is Mike Fitch with the Ohio LTAP Center here at ODOT, and we appreciate your participation. As we get started, please take a moment to locate the questions box in the GoToWebinar panel. During the presentation today, please use the questions box to send in any questions you might have. With that, we will go ahead and turn things over to Don Lamar. Hello.
Good morning, everybody. Thanks for coming back. I hope you enjoyed the first half, and we're going to go ahead and get started. Because of our time, we want to make sure we can get everything in that we can, and make sure you get as much information at you as we can. So we're going to go ahead and pick up right where we were, where Greg Severance was working on his end for the Attorney General's office. Greg, good to see you again.
Good to see you, Don.
Thank you.
Welcome everybody. So I guess might as well get right started. I was talking to Doug Briggs yesterday, so it's a shout out to him. He is attending this course as well, and we talked a little bit about railroad title searches, and he wanted me to remind everybody that this 42-year root of title type search often doesn't work with railroads, because so many of their documents go on back to like when they were first started in the 19th century. Sometimes you just got to go that far back, and they are some really wild, crazy documents. I remember one railroad I was checking out over in Western Ohio, and even though it went through 3 counties, all of the documents were filed in Miami County. Didn't matter where the property was. So, you know, that's just another caution if you get into doing railroads. That can be a real puzzle. So then on this, it kind of segues. Well, before I get into that too, another quick note on Secretary of State and LLCs. When you go and check the Secretary of State's office for LLCs, sometimes there's a comma after the company name, you know, company name, comma, LLC. Sometimes there isn't. Whatever the Secretary of State has it as, with comma or without, that's kind of the official name. So that's what we really look for, and that's what we want on the title report at the AG's office, and that's probably true with ODOT as well. So check the Secretary of State for whether or not there's a comma in there. Sometimes that can make a difference in a search, believe it or not. It shouldn't, but it does. Enough with those two things. Then we're on to the next slide then, 67, where we're talking about what do you attach with some of these documents that are lengthy, in particular, like the pertinent parts. The first page, that'll give you the, you know, grantor, grantee, or the parties to whatever agreement it is, if it's a lease too. Legal description page, make sure we got the right particular parcel that we're looking at, the true subject parcel for the appropriation or purchase. Any condemnation or eminent domain clause. And that's true for leases. Some of these, especially commercial leases, can be really lengthy. A lot of times the parties to the commercial lease don't want to submit that, don't want it. Well, a lot of times all we need is just the page that talks about who gets the money in case there's condemnation or eminent domain. That's kind of all we really need. That's the biggest thing. And they'll of course tell us who the parties are. That's no problem. And signature page, of course, again, that tells us how they signed off or who their representative was for that, which sometimes is quite useful because it can be different than maybe somebody you know, further up or at the beginning of the document. So with that, let's go to the next panel there, Don, if you would. Thanks. Mortgage to individuals, verify the name and address of each mortgagee. I always hate these mortgagor, mortgagee type thing. And the way I always remember who's whom, the mortgagee is not me when you think of it as you as an individual, or the mortgagee is Simon Legree. So the mortgagee is always the bank or whoever's loaning the money. The mortgagor is the one who's taking out the mortgage. So, and landlord, and lessee, lessor, lessee, you have all those type of things. That's why I always prefer landlord and tenant. That's pretty obvious. I hate the ors and es because sometimes they flip, as opposed to what you would think. Canceled mortgages, expired leases, or other interests that are no longer valid don't need to be attached. If you're in doubt, though, if you're not sure, okay, attach that. And then we'll figure it out. That may be a question for the AG's office. Verify if there's any active mineral rights on the property and their proximity to the take. Usually mineral rights cover the entire property. Sometimes you can tell it's pretty obvious what's going on because there might be an oil or gas well or something, pumping along there. So that gives you a pretty good hint. Sometimes all it is a transmission line. And some of those lines can be kind of hidden back in the woods. So hopefully you'll find that. And some of these oil and gas leases, like when power lines come through in particular, and sometimes the gas transmission lines and stuff, they actually are what we call a floating easement. And they cover the entire property. They just may be located at a particular spot right now, but a lot of times they'll cover the entire property. So sometimes if you can, find exactly where that is to see if our take somehow will cause a relocation or something, because that could be, very important. It should be the property owner should be able to clue you into that. And again,
can I ask you a quick question?
Sure, go right ahead.
On oil and gas leases, if you go to such counties like Columbiana, you're going to have 15, 20, 30, 40 assignments of that oil and gas lease. I've had them where they've written them all the way around. Is it true that you only need the most current assignment?
Yes. Very good point, Don. Yeah, otherwise you'll go down a rabbit hole forever. And the only ones we care about are the ones that are active now, that are actually still there. Sometimes even the easement may only run for a particular period of years, and it may have gone away. Maybe it was only for 15, 20, or even 50 years, and 50 years is run and it's gone. So, particularly with some of the older leases, you might want to check and see if there's some specific period that terminates it, and then you don't even have to worry about it. So that's a very good point, though. Go with the most recent assignment, because that will give us the parties that we need to contact. So, well, we might as well move on to the next slide. Well, and again, determine any non-highway, non-utility easement is within the take area. Sometimes there could be somebody that has an easement for a driveway or something, access easement through another person's property. This particularly happens if somebody has sold off a rear portion of the property, and what they have is the road frontage, but maybe there's they've leased out the back field and for farming or something. That's possible. Or maybe there's a house behind them that they sold off as an outlot or something, or their predecessor had sold off as an outlet, and that outlot may have an easement across their property. And sometimes you don't even necessarily know that. They're not always filed, and they should be, because it's an interest in real estate. Any interest in land is supposed to be recorded. That is the statute of frauds in Ohio. You have to record it. But some people don't. Sometimes if you get out in the rural areas, it's Sometimes it just catch can, and sometimes we don't even find out about it till we actually set foot on till the contractor sets foot on the property. If that's the way it is, that's the way it is. But, you know, just be alert to that in case that if you spot something that makes you curious. If the easement is affected, then it has to be described. We have to know what it is. What we mean by affected is, let's say they do have some sort of an access easement, but it's clear over on the left side of the property and all our work is on the right side and we'll never get near it. Well, then that easement is not affected. Don't have to worry about that. You may want to note it since you came across it, but definitely note that it's not affected, that it's not in the take area. As stated in easements, it can include ingress, egress, access, and drainage easements. You know, somebody's ditch runs through another person's property. Okay, next slide. Dealing with unrecorded leases, diligent efforts made to obtain copies of the leases before sending the parcel file to the AGO. Like I said, a lot of commercial leases, maybe all they have, if anything, they should have something, will be a memorandum of lease, which just doesn't tell you much. And that's where, if you can get a hold of at least the condemnation clause and how the parties to the lease are characterized, what's their official legal, you know, name or contact information, that's key. You know, much more so. I don't care about the rest of the lease. You know, all we need is the part that affects us. And that's really the condemnation clause and who are the parties. And negotiator notes must mention whatever facts they can about the lease if the copy can't be obtained. Next slide. Things to watch out for: spelled out names of companies with numbers in their name. Good example is a release of mortgage was missed where the mortgagor was W103 LLC because it was recorded as W and then they spelled it out 103 LLC. Strange, you know, that's sometimes you got to play again a guessing game. Is like, you know, how would somebody else have written this out? Sometimes that's a recorder or something that does that in the recorder's office. It's not anybody that had anything to do with the mortgage sometimes. As was stated, this was missed. The bank was mistakenly named in the case as it appeared. They still held a mortgage interest in the property. And again, banks and mortgage companies are supposed to file these releases. Sometimes they just miss it. They get busy and they don't do it, or they're slow on doing it. Other times, look at liens that may have been paid off. A lot of people don't understand that that lien release typically gets sent to them and then they have to record it, which costs a little bit more money. There's a recording fee and plus the hassle of doing it. So a lot of people just don't bother to record a lien release, even though it's occurred. So that's another thing that happens a lot of times. Make sure any existing liens are recorded in Section 3A of the title report: mortgages, liens, and encumbrances. Here, a lien was missed where an affidavit related to the lien was listed properly in Section 4, but the lien itself was not listed in Section 3A. So I realize there's a bit of duplication in some of these forms, but there's been good reasons for that. We are constantly working and improving the forms. We try not to change them overly, you know, certainly every year, because we want people to be able to work with what's there. But from time to time, if somebody has a good idea out there and says, look, this may be a better way to do it, we listen to that. ODOT and the AG's office, and we work in tandem and try to make the forms as easily readable and as quickly processed as possible for you guys to fill out and get them in. Might as well go to the next panel. Some things watch out for. Possible assignment of mortgage documents. That can be confusing. Like Don said, what we're looking for is the most recent one. Here, an assignment of mortgage was missed because title searcher saw assignment of rents. You know, talk about going back to the 19th century. That's what they used to call it in the olden days, before my time. So that was in the document title, and therefore they didn't list it as an assignment of mortgage. Because it was missed, the mortgage was left out of Section 3A of the title report, and the correct current mortgagee was not named in the petition. And that can be a problem coming along, like I said, in the appropriation with the AG's office. So watch for that too. You know, just a different name for an assignment of mortgage. Typically, it would be assignment of rents. Sometimes people are pretty darn creative though. Next slide. Section 3. Well, that sounds like that's back up to you, Don. So that one too much of me. Did anything we have generate any other questions? And if so, you know, if you think of them later too, we'll always be around, and we still have the rest of this portion to do. And again, I think next Tuesday, May 4th, again, the last hour of this. So with that, Don, I'll turn it back over to you.
All right. Well, thank you, Greg. I appreciate it. Did a great job as usual. I am going back to section 2 where we finished up in section 1. So let's see. All right. So here we are in section 2.
Hey, Don.
This section, yes.
Don, under display settings, we'll just need to switch the presenter view.
Yeah.
All right, thanks.
Better? Okay, thank you, Mike. Sorry about that. All right, everyone. In this section, we're going to learn about definitions of commonly used words, title report for every acquisition, why do a title update and when. We're going to learn about signatures, opinions, and consultants. We're going to start off with common terms and their meanings. This comes from section 5101.04 of the Real Estate Manual. And some of these terms I did go outside of the manual to get, and just because it's something that we do use on an everyday basis that may just not have been covered in there. But the most important one is the owner. Any individual, partner, association, or corporation having any interest, estate, title, or interest in any real property sought to be appropriated. And that comes from the codes 16301E. And then ODOT went ahead and expanded the definition. So we also include all fee owners, life tenants, remainderments, mortgagees, tenants, and subtenants, whether it's a recorded lease or not, and occupants. We also possessors, lien holders, easement owners, judgment creditors, etc. If you have a judgment lien against it, those type of things. And you can find all that right in your instructions section of your RE 46. So again, very important that we've expanded the fact that we just don't go by the owner itself. There are several other people and entities that can be involved. So fee simple, this one is a very, I won't say touchy, but it's a pet peeve of mine. And fee simple is interest is defined as absolute ownership unencumbered by any other interest or estate, subject only to the limitations imposed by governmental powers of taxation, eminent domain, police power, and the power of a state to acquire title to the property for which there is no owner. Now, I got this out of the Real Estate Appraisal Dictionary, And to me, we do see a lot of people putting in 100%. We see them putting in fee, and we'll go over that a little later in more depth on a different slide. So moving on, dower interest. Recently, we've had a change. I'm not going to read this to you. Basically, if your owner is married, the spouse is not required to sign off. There's no dower interest until they are deceased. The owner is deceased. So you can read that a little more. And that comes from the ODOT manual 510101H. Root deed, the most recent deed of conveyance of the entire bundle of rights that describes the property being acquired that has been of record for at least 42 years or more than 42 years. For abbreviated titles, there is no defined length of time required. It could be yesterday, it could be 2 months, it could be 60 years. All root deeds must be either a warranty deed or judicial decree. There's nothing else that is acceptable for your warranty deed. And again, it needs to convey the entire bundle of rights. That comes from our ODOT manual 510104B1. Current deed, that's the document or documents that conveys all interest to all parties falling under the definition of owner. That's basically something we use on the front of our 46 in section 2. We call it the current deed. Basically it is, you could have one current deed, you could have 5 current deeds. It has to add up to all the interests is basically what you're getting to. A warranty deed, and this is very important. Again, this is one of the only, besides the judicial decree, that can be accepted as a root deed. A deed which contains a conveyance or warrant by which the grantor binds himself, his heirs, etc., to warrant and forever defend to the grantee, his heirs, etc., the title conveyed against lawful claims of all persons. A warranty deed may or may not convey the entire bundle of rights. You will sometimes find people will file a warranty deed for just a half an interest, a divided interest, and but that cannot be used as your root deed. You have to have the entire bundle of rights.
Hey,
A
Don,
warranty deed, yes.
we have a question from Thomas who said, would the entire bundle of rights just refer to surface rights?
Yes, mineral rights are a whole different ballgame, a whole different search. Mineral rights are, whole separate. So yes, we're just talking about surface rights. Good question. Continuing on, a warranty deed should contain the words warrant and defend. There's a caveat to that we'll get to soon, but this comes from ODOT Manual 510104C. And here's that caveat I was talking about. A general warranty deed. When you read into a general warranty deed, you're not going to see the words warrant and defend. However, the ORC says that a deed executed in accordance with Chapter 5101 of the Ohio Revised Code has force and effect of a deed in fee simple to the grantee and grantee's heirs, assignees, and successors. This type of deed does warrant and will defend the same from the grantor to the grantee and the grantee's heirs, assigns, and successors forever against the lawful claim and demands of all persons. And again, that's the Ohio Revised Code 530205. So yes, you can use a general warranty deed for your warranty deed. Even though it will not state warrant and defend, it does hold those rights according to the Ohio Revised Code. A judicial decree, a judgment issued by a court or competent jurisdiction that declares the legal consequences of the facts found. Basically, there's an award, and as applied by ODOT's title procedures, a judicial decree must be set forth who owns the property, and such ownership is free and clear of all liens and encumbrances. You can find that whole section in 510104D. Okay, another thing that we run into some issues with is divided and undivided rights. An undivided interest is defined as a fraction or percentage of interest or share in each right, benefit, and obligation with respect to the subject matter of a contract. And I got this out of uslegal.com as our source. So basically, two people can own a half interest. Someone can give away a half interest or sell a half interest of something they own with somebody else or themselves. So that's pretty cut and dry. But when it starts to get a little difficult is when you start dividing up interest. And that is the partition of the land through some legal agreements and documents whereby undivided interest becomes divided interest into individual sole title owners. And it came from Goldmark Commercial Real Estate. I probably could have found that several other different places, but that popped up first on Google. So I'm going to go ahead and give you an example. All right, Mark Mixer owns half of a 300-acre farm, and John Johnson owns the other half. Maybe they're partners, whatever it is. They put it in, a handshake agreement, and they each got half. So John decides to give his son JJ half of his interest. So now what we have is John has a quarter divided interest, JJ has a quarter divided interest, but Mark remains an undivided half interest. I know it can get a little confusing, but when you're running your chain and you're putting those in, it can help the reader, it can help yourself when it comes down to, okay, where'd that quarter go? Why doesn't he have a half anymore? Why doesn't she have a half anymore? So, and as far as this goes, JJ could divide it again, give his son or daughter a half of his quarter, and then you got to start doing math that's way beyond my realm without a calculator. So I'm gonna go ahead and move on. Hopefully everybody understood that. If you got a question on that, please go ahead and send it to Mike, and we'll go back to it. All right. The grantor is a person or legal entity such as a business transferring property ownership to other person or entity on a deed. Basically, the grantor gives the property. And again, that came from pocketsense.com. Again, I could have found that in probably 50 other different areas. That just happened to be the pop up first. And I learned in college that you should always give credit to where you find something. So, grantee. The grantee is the receiver. That's grantor gives, grantee receives. A grantee is usually shown on a deed underneath the grantor. I have never ever seen one that has not. The grantee's never first. It's always the grantor gives it to the grantee, and in the legal it should specify how much they're giving them, and all that good stuff. But pretty simple. Grantor gives, grantee gets, and again that came from pocketsense.com. All right, a mortgage. Yes.
Hi, Don. We have a question from Laura.
Yes,
How is
Laura.
it decided whether the interest is undivided or divided? What language should we watch for?
Basically, the language itself would actually be another entire transfer. Like in our instance, in our example, John would have had to file a deed saying that he was giving JJ a quarter interest, and then the legal description of what the entire property is. I hope that makes better sense. There's not more other than that. And then as you continue through your deed, through your chain, it may go back. But yeah, the only language you're really looking at is a whole nother deed recorded. They can't just add it in and say, hey, I'm giving him, it has to be a recorded document saying that he's giving him the quarter interest of, and then the legal description.
Yeah, Don, if I could, I agree with
Yes.
that. Usually it should say, and that's should, not necessarily does,
Good point.
undivided interest. But sometimes it'll be just like that. Just grantor gives a quarter interest. You can almost assume it's undivided, but the only way you'd know for sure is if they include a legal description of what that interest is. And if it's obviously the entire property, okay, then it must be an undivided 1/4 interest or whatever interest over the entire thing. But if it actually marks out like a corner of the property, 1/4 of it, then that must be what his interest is. An unclear document, but you'll run across those. Sorry, Don.
Yeah. No, awesome point. Fantastic. You're dead on. I get that question every once in a while. Basically, it's in usually the older deeds. They just don't say how much interest was. They only owned a half, but the next deed doesn't specify how much they gave away. So you have to assume they gave the half. You have no other way of knowing. So, and you should never assume, but sometimes you just don't have a choice. So good point, Greg. Thank you. Mortgagor. Mortgagor is the person, couple, or group of people receiving or seeking a loan to buy a home. It could be also a business. The mortgagor is also referred to as the borrower or homeowner in some documentations. And I got that from homeguides.sfgate.com. Again, Google search it and you'll find it 50 different ways. So the mortgagee is the person who is the bank or lending institute offering funds to buy a home or commercial property. So mortgagor, mortgagee, I like to use those when I do a title, and in my 46, I like to identify them that way. Not everybody does. And you want to check our manual to see if there's a little more specification on that. Look at the examples, things of that sort. Something that comes up every once in a while, outsales. Okay, an outsale can be a touchy situation. Some people have a good grasp of it, some don't, and I hope this helps you out a little bit, those who don't have a great grasp of it. But it's a portion of the total acreage being researched that has been sold off and is not reflected in the most current deed or deeds of record. Outsales can be identified when the total acreage of the current deed and the information provided by the county auditor does not match. And as you can see, it's in our manual, 510104F. And so where that leads to is, I think must be in the next one. Basically, the easiest way to think about it is if your acreage on your deed and the acreage of the auditor does not match, then you most likely have an outsale out there somewhere. that now remember, the other thing is also is usually the most current owner. If it was divided up during your search, it should have reflected in the legal description. Again, nobody's perfect. You'll stumble across all kinds of errors, but we'll go over outsales a little more here in a little while. Something I kind of threw in at the last second, and that should have been gone, but transfer on death deeds, and now transfer on death designation affidavit. Basically, a TOD they were usually referred to, allowed an owner of real estate to create a deed with beneficiary designation naming who would inherit the real estate upon their death. So it would say Bill Williams gives Sam Williams upon his death the property. It'll have the legal description. It looks just like any other deed. So you really have to watch. It holds no interest until that person is deceased. And the other fact is, then you're going to have an affidavit filed, which will be the one that actually transfers the property. Now, the good thing is, effective December 28th, 2019, the transfer on death deed went away. And it is now called the transfer on death designation affidavit. And instead of having that deed out there, which they're still floating out there, and you're going to run across them, you can, as an owner, have these 5 bullet points covered, and you will be able to do the same thing, avoid probate, and move forward. So you're going to run into this once in a while. It's not common. It had a little bit of a spurt where everybody enjoyed it, and it was the next new fantastic thing, but it sort of died down, I noticed, over the years. We're going to take a quick look. Mineral rights are, you can see here, rights such as coal, oil, gas, sand, gravel, and they create an estate that may split off from the surface estate. A title search known as a mineral rights search may be used to determine the owner of the mineral estate by researching the historical ownership of the property, locating and separation of oil, gas, lease oil, and minerals from the property ownership, and creating a sequential record of documents showing how the minerals have been changed through the years. And that comes from our ODOT manual 5101-04H. And I have never done a mineral rights search. I get the gist of it. Hopefully I never have to do one, but just there's what the basics are of it. And if you ever come upon it, you're probably going to have to reach out and get some guidance.
Yeah, I was real quick,
Yes,
Don, about that. We did mention before, mineral rights often don't include any surface rights, but there's a caveat. How do you get to the minerals if you need to get through the surface? The mineral right may essentially have an understood right to get to them, such as coal or whatever. Sometimes, like with fracking or oil and gas, it'll be like a diagonal drilling or whatever. So the well may be on another property and they're just draining it underneath that particular property, you know, that we're concerned with, and there's no sign of anything happening, in which case that's all right. I don't see how we would affect the mineral rights, but it's possible, like if it were something that you could dig down to get, say, even gravel, you know, or obviously coal, but there's very few coal mines anymore. But there is strip mining for coal. And what does strip mining do? It strips away the surface. So just be a little bit cognizant of what, you know, there may be there. most places in Ohio do not have the coal. But if you're talking about eastern and southeastern Ohio, yeah, you know, there's a possibility of coal, and that right may still exist, even though more than likely there's not going to be any more, you know, deep mining like that. There's still, you know, somebody could claim, hey, you're interfering with that right. So just note it, you know, note that it's coal or whatever if you can. So that's all I wanted to say on that. So thanks, Don.
No, thank you, Greg. Appreciate it. So, okay, we'll go ahead and move on. Procedures that always apply. And we can see number one, every acquisition parcel file has a title report. All title reports must comply with section 5100 of the real estate manual. The title agent shall use the most recent versions of the RE46 and RE46-1. And where we run into that problem is a lot of people like to pin it to their desktop and just pull it back out and didn't realize that there's a newer version. So, and that's just not with the RE46, 46. That's with any document that you deal with ODOT. All interests in the property to be acquired are to be identified in the title report. Moving on, number 5, at least one business day prior to closing or distributing of funds, the title report is updated. For appropriated parcels, the title report provided to the Attorney General's office, AGO, is to comply with the checklist, procedures, and notification requirements in section 5105 of the ODOT manual. And you're probably going to hear that again a little later. The person signing the verification block on the title report or title update is verifying that he or she is the person who researched the public records. I haven't heard about this in quite a while, but I know in the past, the PM might have someone who is very capable of doing a title report, but is not on the approved list yet, and they may sign somebody else's work. That is frowned upon. That is not going to go over well if it's discovered. Number 8, title reports are not to contain an opinion of title as constitutions of the practice of law. The agent just reports the facts on the report. Very important. Don't say I think this, I think that. There's other ways of noting that you might feel this way or that way. Again, we cannot practice law. That's what we have the Attorney General for. If you have a question, we will reach out to the Attorney General and see what kind of answers we can get. But we are not to speculate ourselves. That's very important. Any consultant preparing any type of title report must be pre-approved by ODOT Office of Consultant Services and be listed on their website as pre-approved for titles. And that goes back to the signature, a little bit of that. Number 10, the title agent is to research all applicable instances within the public record. Sorry about that. If these indices are not available online, the agent is required to travel to the courthouse. Basically, if you can't find what you need, then you need to travel to the courthouse. The websites for the recorders are catching up to our 42-year minimum very quickly. When I started in 1995, we had green screen computers that just listed and that there was something there and you still had to go find it. Now we're at the point where you can do complete searches in a majority of the counties. As much of a hassle Hamilton County can be, you can do an entire search. They have something different than everybody else. They have a series sections of books. and they put those all online. So you can dig out what you need right there at your office or at your desk. So some of these courthouses and recorders' offices, they want you to stay away. They want to keep down the traffic. You know, every time somebody walks in certain courthouses, they have to be empty their pockets and be searched or whatever, wanded. And they're trying to lessen all that. Also, less people in the building could mean less staff to help their bottom line and some other things. So do your best to get as much information as you can before you leave. And then at that time, if you need to go there, then so it be. Number 11, if the agent is uncertain about the effects of a particular conveyance, he or she is to make a copy and include that documentary report. Greg kind of touched on that. If you don't know, if you're not certain it is or is not valid or part of what you need, go ahead and add it, and they will take it apart if they need to. Number 12, the title agent submits a paper copy and an electronic copy to the district office. The copies are to be filled out completely with signatures and attachments. Okay, this was what Greg went over, so we're going to skip ahead and move into section 3. If you have any questions on section 2, go ahead and fill in that box, and we can still go back and revisit it. But moving into section 3, when a 42-year search is required, when can an abbreviated title be used, how to complete an RE46, how to complete an RE46-1, what is an out sale? Again, we're going to go back to the out sale and a little more in depth. And where to put an out sale on the RE46-1, which is always an issue until it's kind of spelled out to, since it's such a rare occasion. Okay, so we're going to start. When to execute a 42-year or abbreviated title report, and you can see there it's in sections 5102.3 and 01 of our manual. So when is a 42-year search required? Anytime the record must be thoroughly searched. And that means basically if you have a fee taking, a complex easement, and it could be a temporary. I had a $68,000 temporary easement a few years back because of the damages that we were causing. It happens. When the title report is updated for appropriation, let's say you did an abbreviated title, which we're going to get into a little more here in a minute. If it's going to go to the AGOs, you have to take it all the way back to 40 years or until a root deed appears. When the FMVE is not based on a waiver of appraisal provisions, and what that's saying is if it's a VA, a value analysis, most likely your DREA is going to allow the abbreviated title report. I actually encourage the abbreviated title report. It's a low risk issue that, or I'm sorry, a low risk where we can save several unnecessary hours wasted. So that source came from the manual 5102.01. So when can you vary to an abbreviated title? May be used when the FMVE will be based on a waiver of appraisal, like we said, when it's a value analysis. Anticipated to have low amounts of compensation. If anticipated to be a $300 minimum offer, something of that sort. There are no complicated valuation problems. There will be no damage to the residue. Approval from the DREA who will need to document the file of his or her agreement. And this all comes from the manual 510301. And if I can touch on number 5 real quick, it is up to the DREA. The RSM usually has, at least in our district, I will give a recommendation to Suzanne, our acting DREA, and she will make that decision. In return, we need something in the file saying that she agreed to go ahead and allow this one search or the entire project to be done by abbreviated titles. Moving on, we're going to look at how to fill out an RE46 for both a 42-year title report and an abbreviated title report. And that's sections 510203 and 510302 of the manual. And again, if you think of any questions from the last segment, please feel free to go ahead and type them in the mic and he'll forward them to me. I have no problem going back and taking a look at something. All right, so we have the top of the RE46, and we need to know that we have to put in our county route and section, our parcel ID, our PID, and I'm sorry, our parcel with its suffix and our PID. We need to know what type of title report, and when we look at some changes, we looked at some changes, and this was one of them that is I find very helpful when you're the reader of the report. And make sure you are using the most current form, and we've been over that. And again, it's very important because, as you can see, if you use an older form from before June of 19, and you will see some of those in this presentation, only because it would have took more effort. It would have maybe screwed up everything. So I didn't want to mess with it, and we'll just spell that out when the time comes. Okay, we're gonna move on to section 1, and that's the name of the primary fee owner or owners. Then we're going to go with the mailing address and the phone number of the owner and the address of the property being researched. Something you need to be very make sure you keep an eye out for is that you do not always use the property address and the mailing address as the same. It can be different. It could be, especially a corporation, it's going to be different. So don't always assume that that's going to be the same. Marital status, spouse's name only if not in title. And that's kind of an odd way of saying it, but basically, if they're married and John and Joanne Crew own this property, but Joanne is not on the deed, then her name will go under marital status. It'll say married and then have her name underneath beside however. But as you can see, most likely in parentheses. So then we need the interest of each owner. And you can have fee simple, you can have a divided quarter, you can have it divided 4 times, 10 times, all depends on the search and who the current owner is and how they acquired their interest. Moving on to number 2, you need a brief legal description including the acreage. You need a volume page of the current deed, the volume page of the root deed, auditor's parcel number, and are there any contiguous parcels? This may not all be in the manual. I'll be honest with you, this is what we do at District 8, and this works out great. The contiguous parcels, I believe is in the manual, and that is very helpful to the appraisers when they do get this title report. So something to really take a look at is the brief legal description. The word says brief, and I see people copying, pasting entire legal descriptions and putting them in there. Not what we're looking for. We are looking for a brief description of the subject premise. So moving on, mortgages, liens, and encumbrances, which is section 3A. You need a volume and page, name of the mortgagee, mortgagor, address, and phone number. You shouldn't have any problem getting a phone number for any of these. You may have a problem in section 1, and if you cannot find it, make sure you address the fact that you did not find it by at least putting an N/A. The negotiator will continue working on it. Date of the document was filed. That's not the date it was signed, it was the date it was filed. And the amount of the lien or encumbrance, and the type of lien that it is. It could be a, I would usually put the type of lien first, which let's say it's a judgment entry and it's for $5,000 plus fees and interest, something of that amount. Because at that point, you don't know exactly what they owe because fees and interest have built up. So you want to make sure if the document says fees and interest, you want to make sure and add that in there. 3B, leases. Okay, you're gonna need a volume and page, a name of a leasee, a leaseor, and addresses of both if possible. You can see right there where that's gonna go. And also commercial, residential. This one kind of a stickler sometimes. I rarely find residential leases. That happens. Some landlords are very proactive in putting those on record, but they're not bound, that I believe, by any law to do so. So it's a expense they don't want to incur. Terms of the lease. Let's say the lease is 5 years, and then you might want to put 5 years starting from 4/5/21, whatever the case may be. Going back to oil and gas leases, something to really watch out for, and is when you look at that ending date, it may say this lease is valid for 5 years or until no longer productive. Well, you could be 10 years out, but do we know if that oil and gas lease is still productive? No. You can maybe drive by and see if there's a pump working or whatever, but if it's not producing any longer, that means that it is valid until it can no longer produce what it was meant to do. So just something to keep in mind. Most likely you're going to end up, any oil and gas lease you run into, you are most likely going to list. Easements, volume and page, name of the grantor and the grantee, and the addresses. Then you want the type of easement, and is the easement in the area tag? That's a very important one that we sometimes forget, but you need to do your due diligence to try and find out. If you cannot be certain whether or not it is, you need to note that. Unable to decipher whether or not it is in the area tag. Whatever language, you just need to let us know that you attempted to find out. Section 4 is defects in title, irregularities, and comments. Any defects or irregularities found during the research process, this information can be on or off record. And I refer to this as my Monopoly get out of jail free card. If I am stumped and I cannot figure out where something went wrong, this is where I'm going to put it. If I see something that is not the norm, this is where I'm going to put it. If somebody at the county recorder tells me, oh, I know them, they don't live there anymore, I'm going to put it there. I know they passed away last week, I'm going to put it there. So you don't want 50 defects and irregularities, but you do want to make sure to point out things that just aren't right. And that is a great way of doing it. You're still giving the reader what they need, and you can move forward with your search.
Don, just to mention,
Yes.
we have reached 10 a.m.
All right. That was fast.
Yeah.
All right. Well, I believe we are going to go ahead and stop the presentation, but we're going to stick around for about 15 minutes if anyone wants to stick around and ask any questions. I am right on that, Mike?
Well, we have the questions box open, so we would invite anybody to type in questions at this time, and we'll provide another minute or two. So, Don, if you want to wrap up any additional slides while we do that, and we'll see if we have any questions.
All right, that's great. All right, taxes, we'll go ahead and move forward with that. Choose the county from the drop box. Township, city, you want to add that in, and school district. Again, we added the drop box, has all 88 counties in it, and a very useful tool. Auditor's parcel number, land values, total values, and taxes per half year delinquent or current. And to go back, something we do not need to know is we need to know if they're current or delinquent. We don't need to know paid up to this date. Again, you could do this title a year ahead of time, 6 months ahead of time, things change. So whoever does pick this up is going to need to look at the most current, which would be an appraiser most likely, need to look at the most current information that they can get a hold of. Special assessments, that's always a question. Where do I put my special assessments? Well, you can see here, all I did was unlock the page, bump down, and put a special assessments mark right there. Very simple, to the point, and don't forget you need to put as much information as far as their code and what it's for. And remember, some are paid per year, some are paid per half. You need to, it'll tell you in the special assessment section of the auditor's card, so you want to make sure and include that. CAUV, we want to check the appropriate box. Yes or no. And then under the comments, if you find out they are in the CAUV program, I would put in there the amount that it's covering. Obviously, that's all going to come into way more of a issue later on if we do affect whether or not we mess up their CAUV status. That is why we want to know that. The acknowledgement section, a drop-down box for the starting and ending dates. We talked about that earlier. Day before yesterday. The ODOT parcel number, 125-T, whatever it may be. Name of the owner will go right there. And then you have a drop down for the counties. And right here is where you put your date and time of certification. And that is very important. And we're going to go over that a little in depth later. And sign, print, name, and title. Don't be shy. Tell us who you are. I especially encourage consultants to put your company name there. next to your name. I encourage that so that I need to know who did this title, where I can quickly get a hold of them.
Don,
Yes.
we do have a question.
Okay.
If there are 2 tracts of land listed on a deed and the take is from tract 1, is tract 2 listed as and more lands in the description or listed as contiguous?
Listed as and more lands. They're correct on the first half. Your contiguous, if the indeed is contiguous, would go in section 2. But you know, sometimes they could put a legal description for a property in 6 miles up the road. So you know, it definitely is the first way. They were exactly right.
All right, thanks. And if you want to do the knowledge check, then we can wrap up.
All right, guys, let's go ahead. We got to have a quick knowledge check. So go ahead and when you're ready, if the owner has the entire bundle of rights for the property being researched, what will go in section 1 interest section? That sounds a little jumbled, but anyway, go ahead and your choices are, I'm even making this a little easier for you. 100% interest, which means completely or entirely. Fee, which is a payment made to a professional person or a public body in exchange for advice or services. Or fee simple, absolute ownership encumbered by and any other interest. And you can read the rest of that and go ahead and make your choice.
So Don, one person typed in fee, one typed in 100% interest, 2 typed fee simple. Several have typed in option C, fee simple, option C, fee simple. Okay.
All right. Those of you who picked fee simple option C are correct. Remember, fee simple means 100%. Let's go back. Absolute ownership unencumbered by any of the other interest or estate, subject only to the limitations imposed by governmental powers of taxation, eminent domain. That is the key right there. Eminent domain, police powers, and the power of the state to acquire property for which there is no owner is cheat. I might be mispronouncing that, but so if you look at fee, that's like paying the appraiser or paying someone for what they did, not the bundle of rights. And 100% completely entirely, okay, that somebody could argue that with me, but I'm sticking with fee simple. That is what we want to see when you go ahead and do it. But good job, guys. That was great. Any other questions or anything, Mike?
No, thanks, Don.
Sure.
And yeah, we will be sending out emails with links to the recordings and the PDF for these presentations. Don, any other things to add?
No, just thanks everybody for being there today. Looks like we had most everybody come back, which is great. And I hope to see you all on Tuesday or hear you all on Tuesday. And if you do have any questions in the meantime, please feel free to call me or email me. I'm in the listings. I probably should, next session, I'll go ahead and put that up there, but you can hunt me down. So feel free to give me a call or an email and I will do my best to answer your questions. Otherwise, thank you, and we'll see you all on Tuesday.
Thanks, Don. Thanks, everybody.
All right. Have a good day, everyone.